What is an unlawful detainer? So in California, the unlawful detainer process is required for landlords to evict their tenant. California permits no self-help. That means a landlord, even though the tenant hasn't paid rent, cannot kick out that tenant by himself or herself. You need a court order, you need a writ, you need a judgment, you need the sheriff's assistance. You cannot go in and physically remove your tenant. That is something the sheriff can do. I've seen a lot of landlords assume that it's just common sense that if someone refuses to leave after the lease expires or refuses to pay or trashes the place, then you should be able to treat them like a trespasser and kick them out. You will learn the law the hard way if you do that. Learn the easy way, the cheaper way from other people's mistakes so you don't have to learn from your own. And that's what I'm hoping to do as a consultant and an attorney. Quick disclaimer, I am not your attorney until I have signed an agreement with you, signed by me. These are general information videos, not intended to be specific legal advice to your specific case. If you need help in your specific matter, you can contact myself or any California licensed attorney, and I'm sure any of us, especially myself, can help you or put you in touch with somebody who can. So California tends to be a tenant and employee-friendly state. There are many obvious and even more non-obvious traps that can befall landlords who think getting rid of a tenant who hasn't paid is as simple as just changing the locks. I've seen many landlords get themselves in trouble by exercising what they assumed was common sense, only to discover that because they didn't properly notify, serve, or get a judgment against their tenant, the tenant ended up having more rights to the property than the landlord. There are many organizations devoted to helping tenants, and I occasionally provide pro bono assistance to them. But I don't feel there's enough help being provided to the landlords, so I'm hoping to tip the scales a bit in their favor with these videos. So you can't ever do a lockout without a writ. And out-of-state landlords are sometimes surprised to discover they cannot unilaterally decide to lock out a tenant who hasn't paid the rent or is in breach of another provision of the rental or lease agreement. Instead, a landlord must get the court's permission to evict the tenant. And in order to get the court's permission, you have to get what is called a judgment in a civil lawsuit, which is called an unlawful detainer. So let me talk about the unlawful detainer. This is California's version of getting you to the eviction. You get the eviction if you succeed with your unlawful detainer suit. The unlawful detainer suit is a summary proceeding in court. It can be with a jury if one side elects, and it usually is expedited versus a normal civil trial. You do have to pay for it as a plaintiff, and as I will discuss in subsequent videos, you can qualify for a fee waiver depending on your financial situation, and the defendant can also qualify for a fee waiver if they cannot afford to file the answer and other court motions or papers. What is real property? So an unlawful detainer suit concerns real property. Now, real property means land and buildings in contrast to personal property. Now, personal property is really anything that's movable, like appliances or furniture, and personal property will not be adjudicated through an unlawful detainer suit. An unlawful detainer suit is primarily focused on whether continued possession of the real property, such as the dwelling and the property for which it sits, should be awarded to the landlord or tenant.